Very good. So I'm not going to read through the slides. You have them. You can read them at your leisure, but I will be just highlighting some points as we go along. All right. And as Jeff mentioned, I'm going to stick around for a few minutes after the class to answer any additional questions that I may not have already answered. All right. So
And folks,
annual meeting elections.
before you get
So,
started, for
yep.
folks who may want the slides now, I did put the link into the chat so you can go ahead and save them now if you choose to. Kirsten, back to you.
Okay, thank you. So we're going to talk about condominium and cooperatives first, and then we're going to discuss elections for HOA. All right. So for condos. All right. Unless your governing documents provide otherwise, the board has to consist of at least 5 members. Okay, so first step is to take a look at your governing documents, which consists of your declaration, your bylaws, and your articles of incorporation. And for this particular point regarding the size of directors, you want to look at your articles of incorporation and the bylaws. Typically, your articles of incorporation will refer to the size of the board as set forth in your bylaws. And so then you go and you look at the bylaws to see the minimum size of the board. Okay. And if your documents don't provide for a minimum size, then you have to have a board consisting of at least 5 directors, unless you have a condominium which has 5 or fewer units. Okay. In which case your the minimum size of the board shall consist of 3 members.
Okay.
All right. Now the terms of directors for condominium and co-ops. The terms of the directors will expire at the annual meeting. That's typically, with some exceptions, unless you have a staggered board. For example, if your bylaws provide for 2 or 3 year staggered boards, then you're going to have an election every other year. So if you have a staggered board of 2 years, okay, your seat might not be up until not the next election, but the following. Okay, and so your seat does not expire until your 2nd year in office. Or if director's term would otherwise expire, but there are no candidates. Okay, so in which case the board just runs over to the next year. Now, if permitted by the bylaws, the board may serve for a term of longer than a year. Like we discussed right now, the bylaws can provide for staggered terms, 2 or 3 years. And if you have older documents that don't provide for a different term, then you certainly have the option of amending the bylaws. That's something that would require membership approval. Now, as of July of 2018, okay, this was a change that went into effect July 1st of 2018, a condominium board member cannot serve more than 8 consecutive years unless approved by 2/3 of the members, or there are not enough people running for the board. Okay, this used to be a confusing section in the statute. Initially, it was unclear whether this is something that could apply retroactively, but the statute was changed in 2018 to clarify that you count the 8 consecutive year terms effective July 1st of 2018 moving forward. So if a director has served for 20 years prior to 2018, it doesn't count. Okay.
Come on, Kirsten. The statutes are they're never confusing. They're clear 100% of the time. Come on.
I mean, attorneys fight over what the statute means. All right, board member eligibility. So the governing documents may require that board members be unit owners. Just to clarify, there's nothing in the statute that specifically says that a director has to be a unit owner. That is something that could be in your governing documents. Now, Chapter 617 of the Florida statute, that's the statute that governs non-for-profit corporations, which your association, a community association, is a not-for-profit corporation. So it is governed under 718, 719, and then or 719 and then 617 as well. So Chapter 617 does say that if a unit is owned by a trust, then the grantor and the beneficiary who resides in the unit are also eligible as unit owners and therefore can be eligible and qualified for board membership.
Hmm.
Now, there could be other eligibility requirements in your bylaws, okay? One that I've seen frequently is a requirement for a board member to reside in the unit, so many months out of the year, okay? Those eligibility requirements, okay, are not in the statute, okay, and therefore could potentially subject the association to legal challenge if you try to enforce those eligibility requirements against board members. Okay, so just be wary of those additional eligibility requirements. Now, in the statute, one eligibility requirement is that a person who is delinquent in the payment of any assessment due to the association is not eligible to be a candidate. Now, the statute was recently, this was amended in 2021. It used to say that any owner or any person who's delinquent in any monetary obligation would not qualify, okay? But that was changed from monetary obligation, which includes, attorney's fees, costs, interest, unpaid fines. It was changed from that to now say assessments. So only if the individual is delinquent on assessments would that disqualify the person from being eligible to run for the board. That means that the individual's name cannot be put on the ballot.
And that makes sense because when I used to manage, it was a huge community and we had our own security force that they actually gave out their own tickets, speeding tickets. Like fines for bad driving in the community would be done by our own security. So with this new law, right, that would mean that as long as I paid my assessments, but if I didn't pay a speeding ticket,
Correct.
I could still run for the board, correct?
Correct, for purposes of eligibility.
Okay.
Now, other eligibility requirements that are actually set forth in the statute include a person who has been convicted of a felony. Okay, you're not eligible to run unless your civil rights have been restored for at least 5 years as of the date that you seek election. Okay, a person who has been suspended or removed by the division is also not eligible to be a candidate. Okay, that means you cannot have that individual's name written on the ballot. Now, in a residential condominium association of more than 10 units, co-owners of a unit cannot serve on the board at the same time. Okay, so typically you'd have a scenario where co-owners, husband and wife, sometimes they want to run and serve on the board at the same time. Can't do it unless the co-owners own more than one unit or there're just not enough individuals willing to serve on the board. And we talked about the law that took effect July 1st of 2018, that you cannot serve for more than 8 consecutive years. Okay, so a candidate means any eligible person who has timely submitted the written notice of intent to run. So if you want to be a candidate, okay, you have to be eligible, okay, as of the last date by which you have to submit your notice of intent to run, which is at least 40 days prior to the election. That is the date, for example, by which your count has to be on assessments, has to be current. Okay, so you must be current by the 40th day prior to the election. Now, what happens is that if you include someone who is not eligible to be placed on the ballot, you can potentially jeopardize the election. So let's say you included all these candidates on the ballot and you mailed out the ballot with your second notice of the annual meeting. We'll talk about the notices you need to mail out. And let's say once you've mailed out the second notice with the ballot, you become aware that, oh no, John Smith should not have been, his name should not have been placed on the ballot. He was not eligible because he was still delinquent on assessments. as of the date he submitted his notice of intent to run. Well, the Florida Administrative Code says that if something like that happens, then you have to send an amended second notice of your annual meeting, okay, with an explanation as to why you need to resend the amended note why you need to resend the second notice with the amended ballot. Now, that amended notice still has to be sent out at least 14 days prior to the election. So if you can't mail out that second amended notice 14 days prior, then the admin code says then you have to basically reschedule your election and then renotice it. But you would only need to do it from that second notice forward. In other words, you don't have to, when you reschedule your election, you don't have to resend your first notice of the annual meeting. You just start with that second amended notice. So you would only have to reschedule the election really at least, 14 days, from the date that you could conceivably mail out that second amended notice. And then you'll have to include the corrected ballot and then everything else that you would normally mail out with the second notice.
So you're talking a couple of weeks, not a couple of months. That's good.
Exactly. All right, so let's talk about the notices and the timeframes for an election of a condominium. So the first notice is called the first notice of your annual election meeting, and that has to be mailed out or delivered or electronically transmitted to owners at least 60 days prior to the annual meeting. Okay, now in terms of delivery, again, you can mail it, deliver it, or you can email it, but you would only email it to those owners who have consented to receive official notices from the association, okay, and then need to have consented in writing. So if you happen to have a roster of units that has, the email addresses of all the owners, but these owners have not consented to receiving official notices in writing, okay, then emailing these election notices, okay, is not the official form of providing them notice of the election. You would have to still mail the notices or deliver it hand deliver it to them. You can email them as a courtesy, but you have to have another method of delivering to them. Okay, once you've mailed out the first notice of the annual meeting, then anyone that is eligible and wishes to run for the board has to submit a notice of intent to run at least 40 days before the scheduled election. Okay, the owner is the one that has to ensure proof of delivery. There is no specific form that the individual has to submit to express their intent to run. I mean, it could be on a Post-it or it could be on a piece of napkin, but the owner has to show proof of delivery. And then from time to time, you might have candidates that want to put together a resume, also known as an information sheet. Yeah. Okay, and if an owner requests the association to deliver that information sheet to the owners with the ballots, then that information sheet has to be submitted to the association at least 35 days before the election. And it has to be on a single page, no larger than 8.5 by 11 inches. Okay. And then your last notice of your annual election meeting is going to be your second notice, which has to be delivered by mail, hand delivery, or email or electronic transmission to those owners who have consented at least 14 days prior to the election meeting. Okay. Now, it is this second notice that is also going to contain your election ballot with the names of all the eligible candidates. Okay, by surname. You're gonna include there a proxy, and we'll talk about that in more detail. Whether it's a limited proxy or a general proxy would depend on whether there's other business that you want owners to vote on. For example, if you want them to vote on amendments or if they're voting to waive reserves, If
Right.
there's anything else that the owners are voting on, then you will need to submit, provide them with a limited proxy. You would include the candidate information sheet that I just discussed, and then you'll also include the inner and outer envelopes. Okay, now if your association also has the authority to collect voting certificates, then you would include those as well. And a voting certificate essentially, it's a document. It's not to be confused with the proxy, but essentially it would apply to units that are owned by multiple owners or by entities. So if your bylaws say if a unit is owned by multiple owners or by an entity, then the co-owners or a authorized representative of the entity has to designate the one individual that is going to be the voting member for that unit. Okay. And if the bylaws require you to have these voting certificates on file, okay, then they become important when you start verifying the outer envelopes. Okay. That means that only the individual that is authorized on the voting certificate can sign the outer envelope for the election. And you would then be in a position to disregard any other envelope signed by a non-voting member.
I ask a question that inevitably comes up after every webinar on elections. And
Yeah.
I don't even know if there's an answer for this, so I'm certainly not trying to stump you or anything. We're on the same team. I'm convinced that at least where I live, the USPS, the Postal Service, has gone back to horse and buggy. Things take forever to get here. So what happens? Are you aware of what happens if something is sent out with plenty of time, well beyond the 2 weeks, like the 3 weeks? They send it a week early, but for whatever reason, through no fault of the owner, it doesn't get to all the mailboxes until a day or two within that 2 weeks, and it is confirmed to be the post office's fault. What happens there?
I mean, the owner can definitely reach out to the association. I mean, as long as you have like proof of mailing,
Okay,
you know,
like
if
the
that was the
timestamp.
official way that you'd have to, the official notice, how official notices are sent out, then you, like I said, you can send a courtesy copy.
Okay.
The only problem with that is the inner and outer envelopes. You
Yeah,
still need inner and outer envelopes for the election ballot, so that could be potentially problematic.
the
And
sticky part.
unfortunately, you can't vote in elections by proxy.
Right.
So it has to be the owner
Yeah.
who signs on that inner envelope. Okay, so then the second notice also has, in addition to be mailed, also has to be posted on condominium property at least 14 days prior to the annual meeting. And your
Right.
second notice is going to also contain your agenda, which typically is just the election, unless there's other business that the association wants to conduct at the annual meeting. Okay. Now, for condominiums with 150 units or more, you also have additional posting requirements. Okay, on a website, you have to have a website, and
Right.
you have to post the notice with the agenda of the meeting at least 14 days prior to that meeting. And then if you want, if owners are voting on any other issues, for example, amendments, then you have to also post that document on the website at least 7 days prior to the meeting. So anything that the owners are going to be voting on needs to be posted on the website as well.
Good.
Okay, electronic notices, not to be confused with electronic voting, which I'll talk about later on in the course. Electronic notices is what I've described, can only be sent to owners who have consented in writing to receiving official notices by electronic transmission. Okay, so you need to have an owner consent in writing. Otherwise, your official notices have to be sent by mail or hand delivered. And then you can, as a courtesy, email it to them. Okay. Electronic notices cannot be used for recall of directors or for retrofitting. Now, big caveat here as well is that once an owner provides his or her email address to the association for notice purposes, that email address then becomes accessible to other unit owners and subject to inspection.
Hmm.
Okay, so if you don't want your email address to be open for inspection, then do not consent to receiving official notices by email.
Something I've seen people do is create another free email, like with Gmail or something, just for association business that has nothing to
Sure.
do with their personal email. So that's something that
Right.
people do as well.
Yep, that's an option. All right, election and quorum requirements. So for condominium and cooperatives only, there is no quorum requirement to conduct an election. The only requirement to have a valid election is that you have to have at least 20% of the eligible voters cast a ballot.
Hmm.
So you have to have at least 20% of the units submit an election ballot. Okay, if you do, then your election can proceed regardless of whether or not there's quorum in attendance at the annual meeting. Quorum, you only need quorum if you're going to conduct any other business on the date of the annual meeting. So you, for example, if you're presenting an amendment to the owners for consideration and approval, or if the owners are waiving on reserves or voting to partially fund reserves or any other issue that requires membership approval, for that part of the meeting, you do need quorum. Okay, whatever quorum is set forth in your bylaws. Okay, proxies cannot be used for elections. It has to be only for ballots, on ballots. All right, so verifying outer envelopes. So verifying outer envelopes, there's really two ways you can do this. Okay, you can verify outer envelopes either at the actual meeting, annual election meeting, or you can do this in advance by an impartial committee. Okay, so let's say you're going to do this by an impartial committee. Okay, the impartial committee then has to consist of members who are not board members, who are not officers, and who's not either a candidate or the spouse of any of them. Okay. If you are able to get an impartial committee, then you can notice a meeting of the committee prior to the election meeting with notice posted on condominium property at least 48 hours prior to your meeting. Okay, that meeting is open to the membership, just like any other board meeting. Owners can attend and basically watch how the committee verifies the outer envelopes. Okay, now the verification of the outer envelopes, okay, consists of basically looking at the outer envelope and confirming that the owner's signature is on it and that there is a unit number. Okay, and you're going to compare that to your roster that you'll have printed out that should contain the names of all the current owners. All right, so you'll look at an outer envelope, you'll see Johnny Smith's signature for unit 100. You'll look at your roster, confirm that Johnny Smith is the record owner. Or if there are multiple owners and your documents require voting certificate, confirm that Johnny Smith is the voting member of that unit. And if so, then you check Johnny Smith off and his ballot is good to go. You put it to the side and you continue verifying the rest of your ballots. You're not opening any ballots at this impartial committee meeting. Okay, once all the ballots have been verified, then you call the meeting, you adjourn the meeting, and then that's it. Okay, you bring those ballots to your election meeting.
Okay.
If you're going to verify these outer envelopes at your annual election meeting, okay, then your first agenda item should be to collect any other ballots that have not yet been cast. Okay, and as you're still collecting, you can start verifying the outer envelopes. You can call out a few volunteers from the audience to see if they would, willing to assist with the verification and the counting of the ballots. Okay.
Okay. That whole thing where it can't be a spouse on the committee cracks me up. I know people who are closer with their cousins than who may live in the same community than their spouse. It should be relatives. It's another one of those things where we talk about the law is not always the greatest thing in the world, the way they construct the different legislation.
Exactly. Now, once you've verified all the outer envelopes, okay, at the meeting, then you'll slice through the outer envelope and you'll start pulling the inner envelopes out.
Okay.
Now, important to note that polls close only when you slice through the first outer envelope. Until that point, any person can walk in with their election ballot and you have to accept them. So polls do not close when you call the annual election meeting to order. Okay, they only close once you slice through the first envelope, which is at the end of the verification process. Once you do that, that's it. Then you can officially deny someone's election ballot if they come in late. Okay. So you'll slice through the outer envelope, you'll pull all the inner envelopes out, then you'll slice through the inner envelopes, and then you take out the election ballot. Okay, if you have more than one election ballot in the inner envelope, you've got to disregard it. Okay, and then you start counting. Volunteers can start counting the candidates, and the election is decided by a plurality of the votes. Now, if two or more candidates for the same position receive the same number of votes, then you have to conduct a runoff election unless your bylaws say otherwise. Typically, bylaws are silent on this issue, so you'd have to conduct a runoff election in accordance with the administrative code. Okay? And the administrative code says that your runoff election has to be conducted no less than 21 days, no more than 30 days after the date of the election. And at least within 7 days of your election, you have to mail out or personally deliver or email notice of your runoff election with the agenda item. You will also include the runoff election ballot, and the only candidates on that runoff election ballot are the runoff candidates, the individuals that receive the same vote. Okay.
Makes sense.
All right. So that was annual meetings for condos. Now we'll talk briefly about HOA elections, which is a much simpler process. With HOAs, unlike condominiums, elections are really conducted based in accordance with your governing documents. Whereas condominiums are very much, creatures of statute, and you got to follow the statutory process. With HOAs, you look to your governing documents and you follow whatever election process is in your bylaws. Okay. There's also no maximum term length or term limits for HOAs. Co-owners, they are permitted to be candidates and serve on the board at the same time. Okay. Really, the only eligibility requirements in the statute for HOAs is that if you've been convicted of a felony, you're not eligible for board membership unless your civil rights have been restored for at least 5 years. And if you are delinquent in the payment of any monetary obligation due to the association, you're also not eligible to be a candidate. Okay, now notice here it's delinquency on any monetary obligation. So with HOAs, if the candidate is delinquent on not only assessments, but any fines or attorney's fees, interest, or administrative fees, or any cost owed to the association, then that would disqualify you. Okay. Now, the time frame by which you have to be current is the last day by which you're allowed to nominate yourself for elections. So we'll talk about nominations shortly. But again, with condos, the last date by which you have to be qualified to run was the notice of intent to run. The deadline by which you have to submit the notice of intent to run. With HOAs, that deadline is the last day by which you're allowed to nominate yourself. Okay. Any other eligibility requirement would likely subject the association to legal challenge if you enforce it, just like with condos.
Yeah.
Okay. Now, again, really, this also is as with condominiums, the association has to hold a meeting of its members annually, and your election of directors has to be conducted at your annual meeting.
Okay.
Unless your governing documents provide otherwise. More often than not, in my experience, elections have to be conducted at the annual meeting. Now, notices of annual meetings for HOAs, there is no, first notice and second notice unless your bylaws provide for that. Okay, but typically, especially in the older documents, there's really only one notice of annual meeting that has to be provided to the membership, either by mail, delivery, or again, electronic transmission if an owner has consented to receiving official notices by electronic transmission. So that one notice has to be mailed out, delivered, or emailed no less than 14 days prior to your meeting. All right, so like I mentioned, elections for directors for HOAs have to be conducted in accordance with your governing documents. So for most HOAs, especially ones with older documents, the process is fairly simple. Okay, you mail out your one notice at least 14 days prior with the agenda that you're going to conduct your elections. Okay, and then on the date of your actual election, your annual meeting, assuming you have quorum, you proceed with nominations from the floor. Okay, and then owners who are present can vote for directors by ballot. Owners who are not present can submit a proxy in advance. Okay, and then those owners who come to the meeting holding proxies, they will get an election ballot for each of the proxies that they've submitted, as well as for themselves, and then they will vote those election ballots on the date of the meeting. That's just your very generic HOA type election. Now, many of our clients have tried to get away from that type of election and have actually amended their documents to mimic more of this condo style election with the first and second notice and the inner and outer envelopes. Okay, or some associations have amended their documents to provide for nominations in advance of the annual meeting. That way they can dispense with nominations on the date of the actual election. But the big takeaway here is that any change in your election process for HOAs, okay, that change has to be done by amendment to your bylaws. It's not a board rule. This is not a board policy that the board can just, implement at a board meeting. This requires an amendment to your bylaws, okay, in order to change your election process. So if you're conducting an election now, and you've been, let's say, conducting this type of election for, the last 10 years, and it's different from what your bylaws provide, you are potentially subjecting the association to legal challenge.
Okay.
Okay, so nominations from the floor, effective July 1st of 2013. If the election process provided in your governing documents allow candidates to be nominated in advance, then you're not required to hold nominations on the date of your annual meeting. But again, you need to have the ability to do nominations in advance in your bylaws, not something you can just implement on your own. Otherwise, you have to take nominations from the floor on the date of your annual meeting. Quorum. Really, your first agenda item on the date of the election or the date of your annual meeting is to establish quorum. Unlike with condominium associations, you need quorum in order to conduct the rest of your agenda, which includes your election. So if you don't have quorum, you can't conduct an election. Okay? And you can't conduct any other business on that day. Unless the lower numbers provided in the bylaws, quorum is going to be 30% of your membership. So if your bylaws, let's say, says that quorum is a majority of the owners, then you default to what the statute says, which says your quorum has to be 30. If your bylaws say your quorum is 10% of the membership, then you go with that.
Okay.
If you don't have quorum, then basically the board existing at the time rolls over, right? Because you can't conduct an election. So board rolls over.
Good.
With a typical election for HOAs, members have the right to vote in person or by proxy, as in the process that I've just described. Let's say John comes in, checks in, and comes in with, let's say, 5 proxies. These would be typically general proxies. So the property manager or the director that is checking people into the annual meeting will look up John Smith, check up his name against the roster, and then would also identify that he has come in with 5 proxies. Okay, you'll find the names of the individuals listed in the proxies, and you can identify that these individuals have voted by proxy. They've submitted a proxy. So then John Smith will get an election ballot for himself and for the 5 individuals that he provided the proxies for. Okay, so after nominations are done, John Smith will write the names of all the candidates and all these election ballots, and then he will vote. That's how you vote by proxy. Now, if the governing documents permit voting by secret ballot for those who are not in attendance, then the ballot must be placed in the inner envelope, and then the inner envelope has to be placed in the outer envelope, and there has to be a designation on the outside of the envelope for the owner to sign and provide their address, property address. So very much like in condominiums. But again, your governing documents have to initially authorize voting by secret ballot at elections. Ballots and proxies are all tabulated on the day of the annual meeting. There is no option to do this in advance, unless, of course, your governing documents provide otherwise. Okay, let's move on to vacancies for condos, co-ops, and HOAs. Unless otherwise provided in the bylaws, a vacancy that occurs on the board before the expiration of the term can be filled by the remaining directors, majority of the remaining directors, even if the only director remaining is basically one director. So if that's the case, okay, let's say there was a board of 5, and let's say 4 directors have resigned, and you have 1 director left. Really, the only thing that that 1 director can do is fill the vacant seats, at least enough of the vacant seats that you can have a quorum of the board, and then the board can conduct business. Okay, so that 1 sole director can do that. In the alternative, the board can also hold an election to fill those vacant seats. Unless provided otherwise in the bylaws, the board members that are appointed to fill those vacant seats, they fill those vacant seats for the unexpired term. Okay, remote membership meeting practices. I'm not really going to discuss this in a lot of detail. You can go through the slides, but this really this has to do with noticing your election meetings and conducting these meetings virtually. This really applied more when, at the height of the pandemic, when we couldn't have in-person meetings. And so a lot of these meetings were happening electronically, virtually through platforms like Zoom.
Same thing with the classes.
Right. The big takeaway here really is that there's nothing in the statute that requires or mandates associations to have these virtual meetings. So if you don't want to have these virtual meetings, you don't have to. Now, many boards still like to give their residents, owners, the option to attend virtually. That's fine. Now, our recommendation is that you still have a physical location. Okay, if you want to have the option of virtual, that's fine, but still have a physical location for the meeting. And especially if you're in a condominium, to have a physical presence for your election. And the reason being is what I've described, you know, an owner can cast the ballot really up to the point where you slice through the outer envelope. So you need to have a physical location where the verification and the counting of the ballots is taking place. And that person can come in at any point until that envelope is sliced. Okay, so if you don't have a physical location for your election meeting, then you're potentially denying someone a vote, right? And that could subject your election to a successful legal challenge. Okay, so have a physical presence. You can just have, you know, the property manager or just the directors be present at that physical location, and everyone else can show up by, you know, Zoom if they want to. That's if you want to give owners the option to appear virtually.
Yeah, it's
All right,
tough to go backwards. Once you offer a convenience, it's
that
tough
is
to
true.
take it away.
That is true. All right, electronic voting. This is for all three: condos, co-ops, and HOAs. So the association can establish, institute an online voting system. Okay, the board can do that. This doesn't require membership approval. The board can adopt a resolution implementing electronic voting. The board needs to meet and adopt this resolution with notice of that meeting, provided at least 14 days prior. Okay. And once the board adopts electronic voting, okay, it doesn't get, it's not an automatic thing that everybody just then automatically has to vote electronically. Owners have to consent in writing to voting electronically, okay? So they have to submit some kind of consent form where they consent to vote electronically, okay? And as they can continue to vote electronically for elections and any other meeting at which board members need to cast a vote until the owner opts out of online voting, in which case they need to opt out also in writing. Okay, so the board institutes electronic voting, approves it at a board meeting by resolution, but owners still have to consent to it. If an owner consents to electronic voting, then the owner casting a vote electronically will count towards quorum. Okay, so the owner doesn't have to physically be present at the meeting. Their vote, electronic vote, counts towards quorum. Now, the statute here identifies what the resolution of the board of directors needs to provide to properly institute electronic voting. And, oh, I think I went too far. And the statute also provides what the platform has to provide, right? It has to have a method of authenticating the owner's identity. The system has to be able to validate the electronic votes. So we've identified here basically what that platform system has to include and contain. So when you interview different electronic voting platforms, they are familiar with the statutory requirements. They should be.
Yeah, they should be.
All right.
And Kerstin, am I correct in saying we highly recommend you going to a company that does something like that specifically? Because while it's easy to install a plain old plugin on your association website and try to do it yourself, you open up your association to all kinds of potential legal issues if it's not conforming to everything that is required, correct?
Absolutely.
So it's best to go to an expert.
Absolutely. All right. Election of officers. So generally, officers are appointed immediately following the election. So once you adjourn your annual election meeting, typically the board will move on to its organizational meeting, which is a meeting of the board of directors, for the sole purpose of appointing and organizing officers, deciding who's going to be their president, vice president, treasurer, secretary, and any other assistant officers authorized under the bylaws. Now, you might have bylaws that say your organizational meeting has to occur within a certain time frame or at a certain time frame, but typically within a few days of your annual election meeting. Now, directors generally cannot vote by proxy or secret ballot. With the one and only exception, they can vote for officers by secret ballot. And it doesn't have to be complicated. I mean, it could be as simple as having the directors write the name of the officer that they're voting for on a post-it. Okay. There is no prohibition against changing officers midstream. So if you feel that your president or vice president or any other officer is not doing their job, okay, the board can meet and decide to remove that individual from that particular officer position and then appoint someone else and reorganize. Now, just want to clarify one thing that's not in the slide. The requirement for an officer to be a director, that is something that you'd have to check for your bylaws. That may or may not be the case, okay? Very specific to your community. If, let's say, your governing documents say that officers have to be directors, okay, then again, the board appoints the officers and the board gets to remove officers. That means they can say, they can vote, Johnny Smith to be president. And if Johnny Smith is not doing a good job, they can say, Johnny Smith, we are removing you from your officer position, and you can remain as a director or you can be the treasurer, or whatever the case may be. What the board cannot do, though, is remove Johnny Smith from his director position. The only one that can remove Johnny Smith from his director position is the membership through the recall process. Okay. Now, board certification requirements. Many of you are familiar with this. Essentially, within 90 days of being elected or appointed, a board member has to either certify in writing that he or she has read the governing documents and will work to uphold the documents and faithfully discharge their fiduciary responsibility. Or in lieu of certifying this, you can attend a division approved course, such as this. You can attend it within 1 year before or 90 days after being elected to the board. And as long as you serve uninterrupted on the board, you don't have to do either of these. Okay, election records and disputes. So any challenge to the election process must be commenced within 60 days of the election results. Okay. So you do have a small window within which to legally challenge an election. The official records. So anything having to do with your election, your ballots, your sign-in sheets, your proxies, your inner or outer envelopes, your notices of meetings, notices of intent to run, information sheets, anything having to do with your election, you have to keep it as part of your official records for 1 year from the date of the election. So, and this includes any ballots that were disregarded. So even though they were disregarded and not counted, they're still an official record. This became a law for HOAs July 1st of 2021. Note that notices must also be kept for 7 years. And for condominiums, minutes of meetings have to be kept in perpetuity. As of July 1st of 2021, a challenge to an election can be brought through arbitration as well as through legal action in court. It used to be that you could only address an election challenge through arbitration. Now you can also bring a lawsuit in court. Election disputes cannot be mediated, though. They're not subject to mediation. Okay, and then just with a few more minutes, recall of directors. This applies to condo co-ops and HOAs. The thing to remember here is what I mentioned. The membership elects the directors, and so the membership is the only one that can remove directors from office. And that is done through a recall process. Directors can be recalled with or without cause. And you can do it one of two ways. You can recall a director through a membership meeting process, or you can do it, which is the more common, you can recall a director through a recall ballot. And you can actually go into the Division of Condominium website and even download an a recall ballot. Okay, and there's even instructions on how to do it. A majority of the voting interests, okay, is what is required in order to recall a director. Okay. All right, that's all I'm going to say about recall. That's it for now. And I guess I'll take some questions if anyone has any additional questions.
Yeah, let's what we'll do. Thank you, Kirsten. Well done. Good job. Very clear and concise. Thank you. Go through the questions. We'll get to as many as we can. We'll give ourselves about 10 minutes or so, I would say. So go through them. In the meantime, I am going to take over the screen share for a second and go over the evaluation process one more time, because folks, while we want you to hang out and listen to some of the answers to these questions, this part's not required. You've earned your credit if you've been here for the entire course. So if you do need to run, we don't want to hold you up. We know many of our cams are swamped right now. So I'm going to share my screen. We just placed a link into the chat. That link is going to take you to this evaluation. Please take the time to fill it out. It doesn't take that long. We want to know how we're doing. We want to know what else you'd like to see us present. This is also how you can get your certificate right now, instantly, as well as the slides that were just used in the presentation. So if you click on that link in the chat, a tab in your browser will open up. And if it asks you, would you like to open up, just choose yes, and then your tab in the browser will open up. Fill this sucker out, hit the submit button, and then after a successful submission, you have a screen that looks a little bit something like this. This acts as your certificate. You can click at the bottom. It says, click here to print this certificate. Your printer dialog box will open up where you go ahead and choose your printer. And then you go ahead and print it. If you don't have a printer, maybe your technology is not working properly right now, whatever the reason might be, pick up your phone and take a picture of it. You can file it that way. That's all that's really needed. You can create a photo file and store it that way as well. In addition, underneath the contact info for Kirsten, which is on the certificate, it says click here for the slides. Click on that here button and the slides will open up. And then you can go ahead and print them and save them that way. I'll go over this again one more time when we're done answering a handful of questions. So for right now, I will turn it back over to Kirsten.
Okay, so I was just reading some of these questions, some very good ones. So I'll just start sort of from the top. Question from Steve: can a condo hold a meet the candidates event? I think certainly that's an option. It's not going to be an official, membership meeting. So you can certainly, notice it as a town hall style meet the candidates meeting, not a problem. This can go for condo co-ops, HOAs.
Run many of those. Oh yeah, I remember those days.
Let's see here. Joe asked the question, are you saying that if there's not a certificate of voting representative on file, that vote won't be counted? So first, look at your bylaws and see if the bylaws require a voting certificate. If they do, typically the bylaws would also say that if you don't have a voting certificate on file, then the vote for that unit will not be counted towards quorum or any other purpose. But again, only if the association really enforces voting certificates. If they haven't enforced voting certificates, even though you have that requirement in your bylaws, it could potentially subject the association to legal challenge if you then all of a sudden start enforcing voting certificates and disqualify a ballot because the individual that signed the ballot is not in the voting certificate. So there is a process of republication that you would have to go through to reinstitute that voting certificate process.
Okay.
Okay.
And Joe, before you go to the next one, Joe, I recognize the name. Welcome back. If you hadn't seen your email earlier, we did re-upload that CE credit from the other class. And if check your portal, your account in a few days, let us know that it took, because we did get the confirmation back that they accepted it. But then again, we did the last time too. So just check and double check. And folks, for those of you who are CAMs, I will reiterate, we will take care of uploading the CEs for all of you after we verify you were here for the entire time. Back to you.
Okay, so for condos, let's see. Deborah, for condos, what happens if not enough people submit their name to run for the board? Well, what's going to happen is, what's going to happen is then, if you have more vacant seats than candidates, then those individuals would just be seated on the date of the election by acclamation. Okay.
Was that Deborah's question? I want to take it
That
off
was Deborah's question.
before
Yeah.
you doesn't confuse you. And for anybody who asked about whether this video will be on our website, yes, give me a couple of business days. We edit out all the fluff at the beginning and the end, and we just put the meat and the bones on there. So it'll be on there in a couple of days at kbrlegal.com, then under the resources tab, webinars and videos. Back to you.
Okay. So question from Janelle. When it states co-owner to be on an HOA board, does this mean that the names must be stated on the deed or marriage certificate? So co-owners mean record title owner. So you have to have a deed that reflects more than one individual. So that is what is referred as co-owners. Okay. Not a marriage certificate, because you could be married and own the unit in your own name. Okay. Question from Teresa. Can the person who's holding the voting certificate attend the annual meeting? So if you're asked to submit a voting certificate, then you'll, email or mail it back to the association, and then the association is the one that's going to be holding that voting certificate. Okay. So yes, the co-owners that filled out the voting certificate are always welcome to attend any meeting. By law, owners are entitled to attend meeting, but that's not to be confused with the proxy. Okay, the voting certificate just says who's the co-owner, basically, that is entitled to cast the vote for the unit. It doesn't really, it's not to be confused with the proxy. And even if you do submit a proxy, you can still show up at the meeting and attend. Okay. You just can't cast a vote in person if you've already submitted a proxy.
Okay. Let's do about 3 more questions. I know it's getting late.
Let's see here. I don't know if this is the same, Teresa. Does the voting certificate needs to be renewed each year? Typically, no, unless there's a change of co-ownership. Yeah. Once you submit it, you're pretty good.
Can you address, there were a couple of questions earlier in that somebody accidentally put into the chat before I turned it off about the board member certification. That's the same whether it's condo, co-op, or HOA.
Yes.
And what's the time, even if there's a 1-day lapse in your service on the board, you have to get certified again, correct?
That's correct. So
Okay.
If you resigned and you want to get back on the board, then you're subject to that certification requirement.
Okay. And it's good to take even if you don't need it every year, because we change those courses all the time to reflect any changes in legislation. So it's
Oh,
fantastic
sure.
review. Fantastic review.
Can the board of an HOA, so question from Enrique Jose, can the board of an HOA remove a member that is not doing all their duties assigned when the person joined the board? So like what we discussed, the owners, the members elect the directors, so only the members, the owners, can remove directors if they're not doing a good job. And that has to be done through the recall process, either by written ballot or at a membership meeting. Directors cannot remove other directors from the board. Okay.
And there are so many questions here, folks. We're not going to get to all of them, so I'm just apologizing ahead of time.
Let's see.
There's a question here. If you were a CAM and get on the board, do you need to do a board cert class? Yeah. If you're a board member, you need to have your board member certification, even if you're a manager. And hey, a lot of those courses, like the one we do, are also good for a couple of IFM credits. You can kill two birds with one stone.
Okay, I think that's it. I think a lot of the questions are sort of repetitive that I feel like I've already answered. So I think that's it.
Wonderful. I thank you. I know everybody here appreciates the time to answer some of our questions here. Kerstin, before I go over the evaluation process one more time, the best way to reach you for whether a client or not, and hopefully if you're in the market or looking for an additional association counsel, we don't make everybody sign retainer fees. Kerstin, what's the best way to contact you?
Sure. So you can reach me, by phone, call the main number, which is 954-928-0680, or by email, khenze@kbrlegal.com.
I thank you for that.
Thank you so much, everyone. And thank you, Jeff.
You're most welcome. We'll chat later. I know you need to run. I'll go over the process.